I am Abhilash. We'll have a few lectures on judiciary, various aspects of judiciary. Can you hear me? But how could you respond? Anyways, can you increase the voice? Oh, online is also there. So we'll have a few lectures on various aspects pertaining to judiciary. We'll begin with Supreme Court. We'll examine High Courts, appointment of judges, judicial reforms, and other important topics. There are various countries in the world. Most of them are democratic republics. But what makes our system distinct is the enormous powers enjoyed by the institution called the judiciary. If I am asked this question, which is the most powerful judicial institution of the entire world, without any doubt, Supreme Court of India can certainly be cited on account of certain vital constitutional provisions and various judgments of Supreme Court. They cumulatively confer this status to India's Supreme Court. From 1989 onwards, we have been witnessing an era of judicial ascendance, and that is going to be more assertive. Means from the time coalition politics started emerging in the center, you would see a concomitant rise. Concomitant means simultaneous rise or ascendance of judiciary, judicial activism, and in particular Supreme Court of India. After over 2 decades, in 2014, you would find a single party coming to power in the center, NDA government of 2014. And that continued till the last election. And in 2014, the most important flagship constitutional reform project of the new government, supported by all political parties, that was 99th Constitution Amendment Act. It was declared null and void by Supreme Court. A highly criticized judgment. So, emergence of single party at the center, wielding power, did not make any difference when it comes to the course of judicial ascendance. And with now, again, coalition politics on the saddle, so this judicial ascendance is expected to continue in a more assertive form. So before going further, let me make a few statements as to how we will proceed with our lectures. You can have reliance on our yellow books. 2 volumes are there regarding Indian polity. So regarding Supreme Court and judiciary, you can have complete reliance. And I'll not be dictating notes as such. as we proceed, except certain important topics. So I would advise you to scribble down points as we proceed to the extent that it does not affect your attention. Scribble down means not verbatim taking notes. You can just jot down points as we proceed. And your mind is rich enough to recall these things in case you read, revise, and discuss these topics, either with yourself or with your friends. So polity is such a topic, such an area, and judiciary is such a topic which is slightly different from many other subjects which you come across due to its technicality, which may render some dryness to the topic. Unless you are inspired by that enthusiasm to demystify and comprehend the apparent technicalities, which are in fact very easy if you understand, then it will become an enthusiasm for you. Once you understand, once you sense that you have better command on those expressions than others, then it will drive you to proceed further. So try to read within 24 hours. If possible, you discuss with your friends. The more you discuss, knowledge is something which is not expected to be confined to yourself. The more you employ the knowledge, greater would be your command. That is more particular in regard to constitutional law. So just scribble down important points, that is sufficient. Expressions, certain expressions as we proceed. And later read it in conjunction with a law book. And you may take newspapers as much as an important source of reading as textbooks, in the sense that polity is such an area where things may turn so fluid and dynamic, in the sense that a topic which you did not read in the class or did not read in the textbook would emerge as of significance in the examination. Even a traditional topic which comes in the question paper does have some connection or roots with the current developments, roots in the current developments. So read newspapers. However, don't be taken for a ride by newspapers or even electronic media. As you are preparing for civil services examination, you shall have to be reasonably judgmental in understanding what is important for your examination and what are propagandistic or what may be a little more revolutionary in its zest but of no significance for your examination. So whenever you read editorial page articles, you ask yourself this question, whether it is relevant for your syllabus or not. So relevance, that you should ascertain, without which you would be wasting your time. Secondly, if you find it relevant, ask yourself this question as to whether this opinion is reliable or not. You should be able to discriminate between material which are not important for your examination, which may mislead your comprehension. They are not seeking revolutionaries in you. They are only seeking smart conformists, in the sense that they are looking for taskmasters. So apply these two yardsticks, and then if you still think it is important, then you incorporate those points in your notebook. It would be better if you write notes on loose sheets so that you can continuously enrich your material so that by the time your examination comes, you will be having a bundle of papers which would be a comprehensive set of notes for what all you should revise for your examination. Going through multiple books on the eve of examination is an impossible task. So try to rely on a single set of material, jot down important points from various sources, and most important of those sources is newspapers. And apart from that, I would advise you to read newspapers for at least 45 minutes a day, thoughtful, intelligent reading, in the sense that more so when it comes to Indian polity, due to the reason that newspapers would empower you with such a dialect. In the sense, dialect means style of conversation in casual terms. Newspapers would empower you with a dialect which may be required to answer Indian polity questions. So, and moreover, it would empower your language itself, in the sense that every day you are coming across new situations as reported by journalists and analysis given by various experts of the domain. So if you regularly read newspapers, new situations are being analyzed, reported, narrated in different terms. So gradually you will acquire that command over language, you will acquire that fluidity of thought, you will come across numerous terms which may be initially unfamiliar to you, but would become so friendly and familiar over a period of time. No current affairs magazine can supplant newspapers when you prepare for this examination. So it's an entirely necessary exercise you have to undertake. 45 minutes to 1 hour or even beyond, depending upon how much you are feeling interested in that exercise. So these much things would be sufficient, and thereafter, if you think that you should read a newspaper, you can, textbook. You can read D.D. Basu, Constitution of India, which is a small introductory textbook, which may be a little dry and sterile when you start reading from the first page. You can leave first 1 or 2 chapters, or you may, you may start from citizenship onwards. So it is a highly appreciated work, scholarly, which may give you some analytical command over the subject. So D.D. Basu, Constitution of India, Introduction to the Constitution of India, that small book that can be relied upon. After completing every topic, I'll give you opportunity to ask questions or doubts connected with the topic, and every single question would be, every relevant question would be comprehensively answered. Intermittent or impulsive doubts may be kept away so that we can comprehensively tackle at the end of every topic. Because whatever may be impulsively sprouting in your mind may be naturally be answered in due course as we proceed. So you can be very much interactive so as to constructively embrace the topic. Well, so if you have any doubt, we have not yet started. Nevertheless, if you have any doubt on whatever we have discussed in the last 5 to 10 minutes, you can ask. Otherwise, we'll proceed. What topics do you teach? Judiciary. I'll have only a few lectures on judiciary. Lakshmikant cannot be compared to D.D. Basu. D.D. Basu was a former judge of Calcutta High Court, and moreover, the author of a multi-volume Constitution of India, which is relied upon even by the judges of Supreme Court while writing judgments. So it is the most He happens to be the author of the most comprehensive literature on Constitution of India. Lakshmikant is a good book. I've seen. I'm not discrediting that. However, you may not go for a cover-to-cover reading, because it does have hundreds of pages of information which may not enrich you in conceptual terms. But at a primary level, if you are in search of information which you may not get anywhere else, you can have a look at Lakshmikant. If you feel interested, you can read. No issue at all. I don't have any difference of opinion, but it is incomparable to D.D. Basu. So you will get command over the topic when you read D.D. Basu, which you may not get. And lack of familiarity of language, or you find it strange due to the reason that you might have started from the very first chapter onwards, like Government of India Acts and all. That's not needed. You start from citizenship. And whatever you may think initially as a little strange would become friendly terrain if you read slowly, if you read every paragraph, then pause, then ponder. It's not about having a marathon. So you read a little, you proceed, you stop, then you try to absorb the essence of what you have read. I'm sure it will be an interesting learning experience. See, preparing for, when it comes to Indian polity, preparing for main examination, or with that perspective, if you approach the subject, that itself will make you rich enough to answer at least 80% of the polity question in your preliminary examination. And even if you read whatever is available, masterly reading, foolproof, even then you can write only up to maximum, you can attempt 90% of questions. So here, reading it from main examination perspective will empower you with that analytical tool to strike at the most appropriate answers. Even UPSC answers at times go wrong, in the sense that they may not be correct in terms of constitutional knowledge at times. So complex questions may come at times. So there your insightful or masterly command, that makes the difference. So you focus primarily on main examination, in the sense that I'm only confining myself to Indian polity. So that will enable you to crack almost all questions. Of course, if you get some additional facts in course of your reading, you keep note of it in your mind for preliminary examination as well. Yeah, some handouts would be there for sure, because you won't be able to pen down everything. That will be given. You can rely on those material as well. In fact, you can primarily rely on those handouts in conjunction with our yellow book. That would be sufficient. Well, yes, I was telling you that if I am asked this question, which is the most powerful judicial institution, I would point it as Supreme Court of India. So we are going to examine what are the distinctive features of India's Supreme Court, which of course by the end of the day make it the most powerful judicial institution. You may think American Supreme Court may be the most powerful. Of course, America is most powerful, but American Supreme Court, in terms of its jurisdictional power, cannot be compared to India's Supreme Court. I'll give you one example. Of course, in due course, we will analyze various issues. But to begin with, in American Constitution, you will find an expression, a term named due process of law. which in simple terms that means that law shall be just, fair and reasonable. So law shall be fair. The executive decisions, legislative enactments, all these things shall be fair, just, fair and reasonable. So this due process clause in American Constitution, as found in multiple provisions, that makes American Supreme Court very powerful. Because if a governmental decision is not just, if it is not fair, if it is not reasonable, they can strike it down. On the other hand, in India, you will not textually find such a provision. So American Supreme Court is textually empowered with such a provision. When it comes to Indian Constitution, Article 21 says that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So the term which is employed in Indian Constitution, that is procedure established by law. If you read Article 21 again with application of mind, you will also understand it in a different flavor or light. Article 21 says that no person shall be deprived of his life and personal liberty except in accordance with the procedure established by law. That also means that a person can be deprived of not only his personal liberty but also life if it is in accordance with the procedure established by law. In my understanding, here lies the root of capital punishment. No court can abolish capital punishment because Constitution categorically recognizes certain situations which may result in state depriving the life of a person. He may be a citizen, he may not be a citizen. Article 21 is person-centric. Rights are available to citizens and non-citizens. So no person shall be deprived of his life and personal liberty except in accordance with the procedure established by law. So the term employed in Indian Constitution is procedure established by law, whereas American Constitution employs this term due process of law. In 1970s, in Maneka Gandhi case, there came a question. What happened was that her passport was confiscated. It was impounded under the passport rules framed under Indian Passport Act. So finally she went to Supreme Court, challenging the governmental decision to impound her passport, raising a question. Well, right to travel out of the country is a fundamental right. My passport is taken away. But interestingly, I was not heard. Without hearing me, my fundamental right got curtailed. Government said, we are not required to hear you. Law provides for that. Procedure established by law. So passport rules clearly gives that power to impound passport. We may not hear. And you know what Supreme Court did? Supreme Court looked at American Constitution, caught hold of the due process principle, dragged it and breathed it into Article 21. and declared that every such procedure, what you say is correct, procedure established by law, but such a procedure shall be just, fair, and reasonable. Thereby, Supreme Court brought in the principle of due process of law into the text of Indian Constitution. This is what is known as procedural due process, in the sense that every procedure prescribed under law shall have to be just, fair, and reasonable. And later, by way of its various judgments, originally that due process principle was confined only to procedure, but over a period of time, Supreme Court expanded its interpretative wings of interpretation got expanded further, and declared that even substantive due process is available in Indian Constitution, in the sense that even laws can be struck down if they are found manifestly arbitrary. Manifestly means so apparently. Arbitrary means we'll do whatever we like by way of enacting law. So originally, the due process principle as brought by Supreme Court in Maneka Gandhi case was confined only to procedure, what is known as procedural due process. Later, it got further expanded by way of various judgments, including Shaira Banu case, triple talaq case. There also, Supreme Court declared that the law, Section 2 of Shariat Application Act, which validated triple talaq as a practice, it was declared unconstitutional to the extent that it endorsed the triple talaq, instant triple talaq. So now you have two Supreme Courts. One is Indian Supreme Court, who is empowered by the Constitution, saying that procedure established by law, empowered in a limited fashion. You have American Constitution flaunting the due process principle, enormously empowering American Supreme Court. But Indian Supreme Court, by its interpretation, brought the same to the text of Indian Constitution. It was expanded by way of interpretation. Now you ask yourself, which court is powerful? Invariably, it is India's Supreme Court. So we are going to examine what are the distinctive features of India's Supreme Court, which make it exceptionally powerful. So I don't read newspaper, but listen to videos. See, videos cannot supplant newspaper reading. It may be engrossing, but it may not enable you to code concepts and information as you read from text. And moreover, your command over language would also not be enriched by way of such an exercise. Of course, if videos make you feel interested in a topic, nothing wrong in it. But text is a differently empowering experience. Videos are meant for comprehending certain topics which you may not find interesting while reading textbooks. But it's only a beginning. Finally, you have to park yourself on the platform of text, because you are writing your answers not by way of making a video. You are writing it on sheets of papers. Part 5, Chapter 4, the Union Judiciary. So here is a question: can we conclude whether procedural due process is equal to due process of law equals procedure established by law? No. They are conceptually different, but in Indian context, to a great extent, due process as found in American Constitution is made available in Indian Constitution in a substantive fashion by way of various progressive judgments of Supreme Court. So part 5, chapter 4, the Union Judiciary. I hope you took it down. Let me clean it first now. See, in United States, you will find dual judiciary in the sense that there is a federal Supreme Court and every state has its Supreme Court. And the jurisdictions are clearly demarcated. Federal Supreme Court cannot interfere with the decisions of state Supreme Court unless Constitution of United States of America is violated, unless fundamental rights are violated and Supreme Court of United States of America needs to provide a conclusive judgment, answer to those questions. Almost all states of America, they do have fundamental rights copied from the federal constitution. So by and large, it is a subsequent development. So American Federal Supreme Court does have that power. And every state has its constitution. Every state has its Supreme Court, not High Court. So in America, every state has its Supreme Court. Every state is supreme to the extent it exercises power acknowledged by its constitution. You know how many cases are heard by American Supreme Court in a year? I mean oral hearing. Roughly 150 cases, 150 cases. American Supreme Court sits en banc. En banc means all the judges, they sit together. 9 judges, they'll sit together hearing every case. Whereas, while they listen only to 150 cases, Indian Supreme Court listens to about 2,000 cases every week. 2,000 cases every week. Indian Supreme Court sits in division benches, while American Supreme Court has only one courtroom. Indian Supreme Court has 17 courtrooms. And most of these benches are division benches of 2 judges. And at times you will find 3 judge benches as well. Rarely you will find 5 judge benches, 7 judge benches likewise. So the jurisdictional space of Indian Supreme Court is far wider than that of American Supreme Court. Because unlike America, which has a parallel judiciary, in India we have a unified judiciary with Supreme Court at its apex, at the apex of the judicial pyramid, which begins with what are known as trial courts at the grassroots level. Then you will find, well, in India you can more meaningfully call the Supreme Court as apex court, because we have an integrated judiciary with Supreme Court at the top of the pyramid. At the grassroots level, you will find trial courts. Of course, these are constitutional fundamentals about which many of you wouldn't be having even a basic idea naturally. So what are trial? What is trial? Rahul Gandhi's defamation case, trial. You might have read in newspapers. So what is trial? Judicial? Initial? Initial hearing. When the case is first tried. So what is trial? Trial happens only once. Let me tell you, the exercise of trial happens only once. Then what follows? It's appeal. So trial happens only once. So trial is essentially a process wherein a court adjudicates a dispute in the light of evidence and applicable law. So this is essentially what is trial. Trial is a process by which a dispute is resolved. Proper expression is adjudicated. A dispute is resolved in the light of evidence and applicable law. If somebody assaults you or throws an abusive word to you, if you are civilized, or disputes are common in our society. So in a civilized society, disputes are resolved by way of approaching authorities who can objectively and fairly decide on who is correct, and trial is a process. So there are two types of trial courts at the grassroots level. One is known as civil court, and the other is known as magistrate court. It's a very basic outline, but which is very much necessary. Civil courts deal with, in some states you may come across the term municipal court. So civil court deals with civil wrongs like property disputes, civil wrongs. Whereas magistrate courts deal with criminal wrongs. And now a question comes. What is the difference between a civil wrong and a criminal wrong? In a civil dispute, if you have a property dispute with somebody, you will have to file the case. You will have to file a suit. Suit means case, lawsuit. And you will have to engage a lawyer. You will have to bring in witnesses. You will have to pay the court fee. And you will have to prosecute the case. You will have to ensure that the case is completed. So in a civil dispute, the affected party will have to bear the burden of prosecuting the case. Whereas in a criminal case, this makes the difference. You are going out of this building, somebody snatches away your mobile, and you are standing stranded. So you will dial 100. Police would come. So it's a case of robbery, not theft. Theft happens without your conscious knowledge. Robbery happens when you are conscious of it. So police would come, would register an FIR. Case gets registered. Police would investigate it. Police would take your statement, would investigate. Whether investigation is effective or not, that's a different thing. Police would investigate it and then would file a report finally after arresting the accused, would file a report before the jurisdictional court. That is a magistrate court in this case, before a jurisdictional court. So the court will conduct the trial of the case. The court will pass a judgment. And what is your role? In civil case, you will have to run and prosecute the case. You will have to run from pillar to post. But when it comes to a criminal case, it is the state will prosecute the case. You are just a witness. Possibly you are prosecution witness number 1. You don't need to do anything. State will do. Why? Because it is in the interest of the state that law and order is maintained. If law and order goes, then the credibility of state itself gets questioned. So criminal wrongs are prosecuted by the state in ordinary course. So at the grassroots level, broadly, you have 2 types of courts. Then at the district level, you have what is known as district court. And there is one more court named Court of Session or Sessions Court. So mind it, this district court is the counterpart of civil court at the district level. District court is a higher court of civil court at the district level. And Sessions Court is the criminal court at the district level. So district and Sessions Court, that is the district level establishment when it comes to judiciary. District court will deal with civil cases and Sessions Court with criminal cases. Now you may think, what is the role of Sessions Court, for example? See, earlier we talked about an offense of theft, for example. The accused is convicted. He is declared as a thief after trial. He can file appeal before the Sessions Court. So Sessions Court is a court of appeal. And it is not theft. Imagine what happened was murder or rape or attempt to murder, more serious offenses. If such a case comes, trial is done not by magistrate court but by Sessions Court. So when it comes to grave offenses, Sessions Court becomes the trial court. Otherwise, it is appeal court. Likewise, small property dispute decided by local civil court by way of hearing what is known as original suit. Original means trial. Then appeal suit can be filed before district court. So district court is a court of appeal. But mind it, if the dispute between 2 individuals is of higher monetary value, so there is a gradation, means by rules differentiation is made. If it is 5 lakhs or 6 lakhs, depending upon the rules of the state. or 10 lakhs, it would be before the civil court. If it is 25 lakhs and above, that depends upon the rule of the state. Then the trial happens at the district level. See, we have these many states. There are differences in state judiciaries. So depending upon the rules, the case would be tried either by a senior civil court or by a district level court. Anyways, it's not by civil court as such, but by a higher court. So, district court conducts trial of disputes of higher pecuniary value. Pecuniary means monetary value. Whereas, while it also hears appeals against the cases decided by civil courts. Now, on the top of that, you have what are known as high courts. And be aware, the courts till high court, they are known as subordinate judiciary. All courts till high courts are known as subordinate judiciary. And why it is called subordinate? How is it subordinated? All such courts are under the administrative and judicial control of the High Court. So all courts within the territory of the state are under the administrative and judicial control. Now you may think, what is administrative control? Recruitment of judicial officers, transfer of judicial officers, means judges, day-to-day administration of importance, framing administrative policies. So subordinate judiciary is under the administrative control of the High Court, and it is also under the judicial control of the High Court, in the sense that judicial control means if a subordinate court passes an illegal order, you can immediately go to the High Court under Article 227 of the Constitution to get the order corrected, and then the trial court may proceed. So High Court has both administrative and judicial control over the subordinate judiciary. And High Court, on the other hand, with Supreme Court, they are referred as superior judiciary. So superior judiciary and subordinate judiciary. What are superior courts? Why are they called superior courts? Because they have a lot of commonalities. Both are the birds of the same feather. Both are constitutional courts. High Court and Supreme Court are constitutional courts. What are constitutional courts? Are they courts mentioned in the Constitution? No. Even district court is mentioned in the Constitution. So constitutional courts are those courts which have the power to interpret the provisions of the Constitution. So both are constitutional courts. is something very interesting. As and when a high court finds that a case pending before a subordinate court contains, so if you have any difficulty in, I'm telling you slowly, but if you have any difficulty in comprehending whatever we are discussing, you let me know. So if at any time the High Court finds that a case pending before a subordinate judiciary contains a substantial question of law as to the interpretation of the Constitution, then the High Court shall not allow the subordinate court to proceed. Rather, High Court shall withdraw the case to itself and shall decide the case. So they cannot, subordinate court cannot interpret constitutional provisions. So in such a situation, the High Court shall transfer or withdraw the case to itself. Now you may think of a few terms which are of seminal significance. Substantial question of law regarding the provisions of the Constitution. For understanding what is a substantial question of law, you need to understand what is a question of law. So you will find, see, so many laws, so many enactments like Right to Information Act, BNS or erstwhile IPC, Indian Penal Code, Bharatiya Nyaya Samhita. So you'll find so many laws. And things are clearly written in those laws. Everything is written. But at times, there will arise a question for which there is a requirement to give interpretation. So, when such a question arises and there is no interpretation available as given by a High Court or Supreme Court, then it becomes substantial question of law. If the question has a clear answer, then it is only a question of law. I repeat, when it comes to a law enacted by the legislature, if a question comes up, if it has a clear answer, either as found in the statute or given as an interpretation by any High Court or Supreme Court, then it is only a question of law. If the question requires an interpretation from a constitutional court, then it becomes a substantial question of law. For example, whether National Green Tribunal has power to initiate proceedings suo motu. Till 2021, there was no answer given by Supreme Court or High Courts in clear terms. So in 2021, Supreme Court passed a judgment. Now it is clear, law is settled. The term settled in constitutional law means an authoritative answer is given by Supreme Court. So now the law is settled after 2021. National Green Tribunal can initiate proceedings suo motu. Like floods happened in the southern state Kerala or in Uttarakhand, or some incident of such magnitude happens anywhere. If environmental degradation is a result, is a reason for the tragedy, by reading the newspaper report or by watching television report, NGT can take case by itself. So NGT Act of 2010 nowhere says that NGT has that power. So the question became a substantial question of law. Supreme Court gave answer, settled the question, and as a result of which now NGT is clearly conferred that power by Supreme Court by interpreting the provisions of NGT Act. Now you know what is a question of law, what is a substantial question of law. Then comes the term which we started with originally, substantial question of law regarding the interpretation of the Constitution. It simply means if such a question arises from the interpretation of nothing but Constitution itself, then it becomes a substantial question of law regarding the interpretation of the Constitution. Under Article 145, Clause 3, such a case can be heard by a bench consisting of not less than 5 judges. So, whenever Supreme Court finds a substantial question of law regarding Constitution to be answered, Chief Justice shall constitute a bench consisting of at least 5 judges, a minimum of 5 judges. So this is what is known as Constitution Bench. It can be of 5 judges, it can be 7 judges, it can be 9 judges, it can be 11 judges. It has reached up to 13 judges in Keshavananda Bharati case. So coming to now 3 terms you understood: question of law, substantial question of law. Okay, you can take down substantial question of law. I'll just give one sentence dictation. Substantial question of law. It is a question of law that has not yet been settled by Supreme Court. By the way, keep in mind, in clear terms, a substantial question of law can also be answered by the High Court. But since we are discussing Supreme Court, a substantial question of law answered by the High Court can still be appealed before Supreme Court. For example, Madras High Court might have taken a point of view and Bombay High Court might have taken a different point of view while answering the same question. So ultimately, Supreme Court will have to settle. So the question of law settled by Supreme Court has finality in the sense that there is no court beyond Supreme Court. Then you may take down the next point, that is Constitution Bench. Constitution Bench. Under Article 145, Clause 3, under Article 145, Clause 3, a case containing a substantial question of law regarding the interpretation of the Constitution, regarding the interpretation of the Constitution, shall be heard by a bench consisting of not less than 5 judges. So you know what happens in practical terms. Imagine Supreme Court is hearing a case. The judges find that there are some constitutional questions involved which need to be answered. They will not decide it. They will refer the case to Chief Justice to constitute an appropriate bench. Even if there is constitutional questions to be answered by Supreme Court, but still they can only say that let the file be placed before the Chief Justice to constitute an appropriate bench. It is for the Chief Justice to decide as to whether the bench shall be, for example, a 2-judge bench might have passed such an order. There is no necessity that Chief Justice shall constitute a 5-judge bench. Chief Justice may constitute a 3-judge bench if he has doubt as to whether this should go to 5-judge bench or a larger bench than the 2 judges. Or he may constitute a 5-judge bench. If he is of the view that the case shall be heard by a 7-judge constitution bench, he can straightaway constitute. These are the pervasive powers of Chief Justice, expansive powers of Chief Justice. So, we are coming back to our discussion. I was telling you that High Courts and Supreme Court, they are constitutional courts having the power to interpret the provisions of the Constitution. Secondly, both have the power of judicial review. What is judicial review? It is that power which is conferred on a constitutional court to invalidate a government decision. You listen, I'll dictate a sentence in simple terms. It is that power which is given to a constitutional court to invalidate a government decision or even a legislative enactment if it is violative of the Constitution. So a government order or a notification can be quashed by a constitutional court, or even a section of a legislation can be declared, like electoral bond scheme. It was a scheme promulgated by government. It was quashed by Supreme Court. And there were some enactments amended by Parliament as part of electoral bond scheme. Those amendments, they were also declared null and void. As a result of which, electoral bond judgment is a case where Supreme Court not only quashed a government order, but also invalidated amendments made to various laws. So judicial review is that power with 2 hands, one to annul government decisions, the other to set aside legislative enactments or its sections. Take down judicial review. It is that power available to constitutional courts. Constitutional courts. To invalidate government decisions. In brackets, you may perhaps write executive decisions. And legislative enactments. Which are found to be violative of the Constitution. Then understand that both, when High Court interprets a question, is the bench also called Constitution bench? No. Whenever High Court interprets, High Court answers to a constitutional question, High Court can do only to the extent that its answer is in conformity with the judgments of Supreme Court. So High Court can decide only holding the umbrella of Supreme Court judgments, in the sense that it cannot go against it. High Court has such power. High Courts are also constitutional courts. But because Supreme Court is the last court, when it decides on a constitutional question, that conclusive decision shall have broader heads involved, or it should have a minimum number of people involved, so that the law gets conclusively settled. When it comes to High Court, there is no such provision in the Constitution. But Constitution says that a constitutional question, you will come across it with clarity only later, but since I am answering this doubt, Constitution says that when High Court answers a constitutional question with regard to which Supreme Court did not pass any judgment, the High Court can give even a certificate to the litigant, saying that we decided it like this, but we acknowledge that there is a constitutional question involved, which may be heard by Supreme Court on appeal. You can challenge our decision. You may go to Supreme Court. We have decided a constitutional question, but we recognize that there is something important over which Supreme Court's application of mind is necessary, or it is desirable. So High Court can even issue such a certificate. Then both Supreme Court and High Court, they have what is known as contempt power or contempt jurisdiction. I will tell you in a nutshell what is contempt. If you disobey an order of the court, be it small court, high court, or the highest court, if you disobey an order of the court in a willful manner, you know that you are doing this mischief, but still you do it, then you can be punished for contempt of court. And subordinate courts do not have this power. This power is vested with High Court and the Supreme Court. If you willfully violate an order of a subordinate court can only make a reference to the High Court. High Court can only hear the case, not the subordinate court. But on the other hand, High Court can hear contempt cases coming from subordinate courts, as well as how High Court itself can punish people for violating its own orders. So High Court's contempt jurisdiction has two limbs. One is contempt against itself. Second is contempt with respect to the subordinate courts. On the other hand, the Supreme Court's contempt jurisdiction is only confined to itself, in the sense that if you willfully violate an order of Supreme Court may punish you. Supreme Court can punish you. If you violate an order of the High Court, Supreme Court can't do anything. Only High Court can do. In other words, contempt jurisdiction of contempt jurisdiction of High Court is broader than that of Supreme Court, because the power with respect to the subordinate courts, that power is given to High Court under Contempt of Courts Act, which is a law enacted by Parliament. So, under this 1971 law called Contempt of Courts Act, High Courts have contempt power with respect to subordinate courts. And now you may have a question in your mind. If High Court decides on a contempt petition, can somebody challenge that before Supreme Court? Yes. It can be challenged before Supreme Court, because Supreme Court is the highest appeal court. So both have contempt powers. So you will find that, well, let me tell you one more thing. The judicial review power of the High Court is as good as Supreme Court. It is not of inferior quality. It is as good as Supreme Court. I'll tell you one or two examples. Just imagine, President's rule is declared in a state. Means Article 356 is imposed in a state by way of dismissing the state government. You know, even a High Court can declare President's proclamation as unconstitutional. High Court has a power to do that. I'll give you an example. You might have heard about central government imposing President's rule in Uttarakhand in the year 2016. Harish Rawat was the Congress Chief Minister of Uttarakhand. In 2016, the government was dismissed, against which Harish Rawat filed a writ petition before the High Court of Uttarakhand, and in this case, Harish Rawat versus Union of India, Uttarakhand High Court declared President's proclamation as unconstitutional and restored Harish Rawat government. Against which central government approached the Supreme Court, filing an appeal. I remember the contention by the central government was that High Court could not have done it. So till then, High Court never did it. How can High Court invalidate a President's proclamation issued under Article 356? Only Supreme Court can do it. Supreme Court immediately said, they are also constitutional court. They can do it. And in course of the hearing, after due hearing, Supreme Court not only declared the power of the High Court, but also affirmed the decision of the High Court on its merits. So in 2016, in this case, Union of India versus Harish Rawat, Supreme Court affirmed the power of the High Court to invalidate President's rule, proclamation issued under Article 356. Now you may think, Union of India versus Harish Rawat. Earlier what we heard was Harish Rawat versus Union of India. What is the difference? See, whenever you come across what is known as cause title, the title of a case, This is what is referred as cause title. The first name which is found is either of the petitioner or the appellant, the one who filed appeal. So in Supreme Court cases or in High Court cases for that matter, the one who went there as petitioner is the first person. So in Harish Rawat case, the one who came to Supreme Court is Union of India. So Union of India versus Harish Rawat. Harish Rawat filed petition before Uttarakhand High Court. So there it was Harish Rawat versus Union of India. It is, I'll come to you. So not only the government decision can be reviewed to the extent that President's rule even can be declared null and void, but also even a constitution amendment can be declared null and void by a High Court. So you see how powerful is High Court's power of judicial review. I'll tell you an example. 97th Constitution Amendment Act. With regard to cooperative societies, it was challenged before Gujarat High Court. 97th Amendment Act was enacted by UPA government. And Gujarat High Court, in this case, Rajendra N. Shah versus Union of India. This was the name of the case. Gujarat High Court declared some sections of the Constitution Amendment Act null and void, against which central government came to Supreme Court by filing an appeal. And Supreme Court, in the case Union of India versus Rajendra N. Shah, 2021, Supreme Court not only affirmed the power of the High Court, but also endorsed the correctness of the decision of the High Court. So mind it, even an amendment to the Constitution can be challenged before a High Court. Such is the expansive power of the High Court. But interestingly, Supreme Court remains supreme. I'll tell you why. High courts are not under the administrative control of Supreme Court. Every High Court has its own autonomous, constitutionally autonomous administration. Supreme Court does not pass any direction to High Court in usual course. Supreme Court always refrains from passing such directions, because High Court is also a constitutional court. The power of judicial review as available to the High Court is as good as that of Supreme Court. But Supreme Court remains supreme in the sense that we have these many states and these many High Courts, and there may be difference of opinion between various High Courts on legal issues. So it is a systemic necessity that we should have a last court, a Supreme Court, which has the power to declare legal principles. Imagine, Tamil Nadu has a state law, Assam has a state law. Tamil Nadu will be governed by, to that extent, will be governed by the state enactment of Tamil Nadu. Assam will be governed by the state enactment of Assam governing that subject. But the legal principles regarding its interpretation shall be uniform for the entire country. Those principles are declared by Supreme Court. So having a last court as the federal court, as well as the court to declare legal principles, is a necessity for the entire country. High courts are not subordinate court to Supreme Court. High courts are not inferior courts to Supreme Court. But Supreme Court is supreme due to this peculiarity. These many states are there. These many high courts are there. So there shall have to be one last court. So which is the expression? Can you identify the term by which we can denote the relationship between Supreme Court and high courts? The term is coordinate courts. So this is the exact relationship between Supreme Court and high courts. They are coordinate courts. So you can have a question in your examination, be it preliminary or mains. Examine the relationship between Supreme Court and High Court. So this is the precise terse answer. And mind it, very interesting. Supreme Court cannot issue a writ against a High Court on the judicial side. While hearing a writ petition, Supreme Court cannot issue writ against the High Court on the judicial side, but it can do so in the administrative side, on the administrative side. Now you may think, what is the difference between administrative side and judicial side of Supreme Court and High Court? Very simple. Every court for that matter has two wings. One is judicial wing, that is about hearing the cases. Administrative wing is about the administrative department of the court. Like for example, here you have teachers lecturing on various topics, but admission is taken elsewhere. Your admission process is regulated. Your candidature is regulated, or services are provided by a separate wing. Likewise, every high court has its registry. Supreme Court has its registry, which is involved in filing the cases, numbering the case, listing the case, and other things like recruitment of employees of Supreme Court or High Court, all other aspects. So Supreme Court can issue a writ against a High Court on the administrative side, but not on judicial side. Writ cannot be issued against judges, because judges sit on judicial side. So that itself is an example to exhibit that Supreme Court and High Courts are coordinate courts. Nobody is superior, nobody is inferior, but Supreme Court is supreme. Like you read in yesterday's newspapers perhaps, that a judge of Punjab and Haryana High Court made some observations against Supreme Court. And Supreme Court the next day expunged those observations, removed those observations, and expressed judicial restraint in not initiating any contempt proceedings against the judge, despite his acidic remarks. Supreme Court said that, well, a High Court judge should not have made comments against the Supreme Court. It is not sustainable in law, because High Court decision is appealed before Supreme Court, and Supreme Court passed an order. So you have to honor that order. I told you, High Court has contempt power, but the decisions passed in such contempt cases can be appealed before Supreme Court. So appellate jurisdiction is available to Supreme Court. So High Courts are coordinate courts, but Supreme Court is supreme. Well, so we have done a brief survey of the entire architecture. Secondly, we are discussing what are those distinctive features of India's Supreme Court. Can you scroll back? Some doubts are there. If the constitution amendment is declared null and void by a High Court, is it applicable to all states? Very interesting question. It may be a constitution amendment. It can be a section of Right to Information Act or any such law. If such a provision is declared null and void, mind it, the law is killed at its source. It's not only with respect to a state. In the sense that, be it constitution amendment or a section of an enactment, if it is invalidated by the hammer of judicial review, so the skull is broken, the section dies there. But immediately, the government will approach Supreme Court the next day itself. Ultimately, Supreme Court will decide. On the other hand, if a government decision is declared null and void by the High Court, with respect, then that becomes applicable with respect to its territory. But if a law is declared null and void, then the law becomes invalid. Immediately, central government will approach Supreme Court. If there is less than 3 judges in the bench, which question of law is it? Less than 3 judges means then only 2 judges. Supreme Court hears only, in Supreme Court, most of the cases are heard by division benches of 2 judges. Only some cases are heard by single judge, like matrimonial transfer petitions, bail applications of less than 7 years term, such offences. So most of the cases are heard by division benches in Supreme Court. Can you further scroll down? Who decides the number of judges? It is Chief Justice. Further down. Well, criticizing judgments of courts and public platform by an ordinary citizen is also. See, you can criticize. Judges are not holy entities, nor courts are holy. You can criticize, but it should be in a healthy fashion. You cannot criticize the judge, you can only criticize the judgment. But even when you criticize, you can be strong in your criticism, but you cannot attribute motives to the institution. So, reasonable, balanced criticism, howsoever strong, is welcomed in a constitutional democracy, and courts also honor it. But unhealthy criticism means judges cannot reply to your allegations, as a result of which the credibility of judiciary would get affected. So it's not to protect judges, but to protect the seat of justice that contempt jurisdiction is available. Well, so we discussed this aspect. Secondly, India is the only country in the world where judges appoint themselves, in the sense that in India, judges of constitutional courts, don't write like that, I'll give you a different term. Judges of constitutional courts are appointed by a mechanism where judges take a decision. So India is the only country where judges decide in final terms as to who shall be appointed as judges of constitutional courts. I'll make it clear, like in America, it is for the president to propose the name of a person to be appointed as a judge of Supreme Court. American Constitution, you missed the point. So I was telling you that in India, Judiciary decides as to who shall be appointed as the judges of Supreme Court and High Courts. And you won't find it in other major democracies, constitutional systems. In America, President can appoint anybody as a judge of Supreme Court. Constitution does not lay down any criteria. Any Tom, Dick and Harry can be appointed as a judge of Supreme Court. But the name proposed by President will have to be confirmed by Senate, upper house of American Congress. Senate may hear the person, they may summon the person. By way of a process called a confirmation hearing. And if Senate confirms, the appointment becomes valid. The process gets completed. But in the history of American Constitution, over these centuries, from 1787 onwards, only 12 to 13 times American Senate outrightly rejected the nomination made by President. It is customary on their part to confirm it. You know how judges are appointed in United Kingdom. United Kingdom has world's youngest Supreme Court, because they established their Supreme Court in 2008 by way of Constitutional Reform Act, which came into force, Constitutional Reform Act of 2005, which came into force in 2008. Till then, House of Lords was the highest court. Judicial Committee of the House of Lords was the highest court. So they created a separate Supreme Court by way of passing a parliamentary law named Constitutional Reform Act. And there is a body named Supreme Court Judges Selection Committee in United Kingdom. So this is the body which recommends names to law minister. So there is a separate body, I repeat, which will give recommendation to law minister as to who can be appointed as judges of Supreme Court. Law minister is known by the name Lord Chancellor. They call him by the name Lord Chancellor. So Lord Chancellor can either accept the recommendation by which appointment happens, or may send it back to the committee. Committee may recommend the name again. Law minister can again send it back. So the final veto power is with Lord Chancellor. So mind it, in US, power lies with primarily, the process begins with President. Power primarily lies with President. In UK, law minister can, though he does not have the power to choose, while in US, President has the power to choose. In UK, law minister does not have the power to choose, but he has the power to reject. So in both the cases, executive plays a very important role. On the other hand, in India, from 1950 onwards, it was for the President to decide as to who shall be appointed as judges of Supreme Court and High Courts on the basis of the advice given by Council of Ministers. So 1950 till 1993, the power was exercised by government in effect. Effective power was exercised by government. But in 1993, we'll discuss this topic in great details at a later stage. A judgment of Supreme Court, a 9-judge bench, in what is known as second judge's case, declared that the opinion of Chief Justice shall be final while appointing judges. So President is finally bound by the view taken by Chief Justice, as a result of which till 1993 government was on the driver's seat. After 1993, judiciary itself is steering the vehicle. So that makes Indian Supreme Court exceptionally powerful, extraordinarily powerful. A country where judges are appointed by a body of judges. Thirdly, confirmation hearing. Thirdly, India is the only country where India is the only country where Supreme Court has the power to pass any order. I'll dictate, you just listen this point, I'll dictate. Supreme Court has the power to pass any order to do complete justice to the parties in a case pending before itself. So it is an untrammeled power to pass any order. So there is a provision under Indian Constitution called Article 142, under which it can pass any order to do complete justice to the parties in a case pending before it. So nothing can come on the way of Supreme Court. It can pass any order to do complete justice. Interestingly, Constitution does not define what is complete justice. As a result of which, it is for the Supreme Court to decide as to what is complete justice in the facts and circumstances of the case. I'll give you one sentence, then we'll discuss further, so that it will become clear for you. Under Article, you can take down, under Article 142, Supreme Court has the power to pass any order to do complete justice. Okay. So, Supreme Court has the power to pass any order to do complete justice to the parties in a case pending before itself. Full stop. As the Constitution does not define, the term complete justice, it is for the court to decide on the scope of the term. To decide on the scope of the term. In the light of the facts and circumstances of the case. Yeah, be aware that the power under Article 142 is not the power to initiate any proceeding. Instead, it is only a power which can be employed to decide a case pending before itself. Just imagine, Supreme Court is hearing a case. A case is pending before the court. While deciding the case, Supreme Court can invoke Article 142. Nobody can compel Supreme Court to exercise this power, number one. Number two, this power is very rarely exercised. Only in rare cases. And what is the scope of exercise of the power? I'll tell you. Just imagine a case where law provides for something, but if the court goes in accordance with the strict terms of law, the court will feel that the parties may not get complete justice. So by employing Article 142, you know what the Supreme Court does? It can jump the fence of law with a rose of relief on its hand to be given to the litigant. In the sense that to do complete justice, the court will jump the fence of law. It will not have any precedent value in the sense that this is only in one case. Court exercised its special power to give relief to somebody, taking note of the factual peculiarities of the case. At the same time, over a period of time, the scope of article, like Ram Janmabhoomi Babari Masjid case, what is known as Ayodhya case, as decided by Supreme Court in the year 2019. What happened was that it was a dispute over a piece of land claiming to be places of worship as claimed by people belonging to two communities. So it was only a civil suit. So Supreme Court decided the case in favor of one of the parties after the appeal is heard. Originally the case was pending before the District Court of Faizabad, from where the case was transferred to Allahabad High Court. And Allahabad High Court had decided the case, against which all parties filed appeal before Supreme Court. And Supreme Court decided the case in favor of one of the parties, but taking note of the peculiarities of the case, Supreme Court invoked its special power under Article 142 to give a direction to the state of UP to allot 5 acres of land to the party who lost the case, to enable him to construct a place of worship. So this never happened in the history of Indian judiciary. In a civil case, if the one who loses the case is given compensation, then there will be no land left in this country. But taking note of the peculiarities of the case, its wider social ramifications, socio-religious aspects, Supreme Court invoked its special power. Though as per law it is not possible, but still by invoking its special power, What is not otherwise possible is made possible by Supreme Court. Likewise, over a period of time, the scope of Article 142 got further expanded. It got further increased by way of Supreme Court passing orders under Article 142 to fill legal vacuum. I'll put it in other words. Imagine there is a vacuum in law. There is an absence of law, which results in gross miscarriage of justice, which will be violative of the rights of the citizens. Supreme Court can invoke its power under Article 142 to fill that legal vacuum so that rights of the people are not violated. What is referred as Vishaka case or Vishaka versus State of Rajasthan, 1997. So in Vishaka case, what happened was that Supreme Court many a time requested government to introduce a bill in Parliament to enact a law protecting women from sexual harassment at workplace. See, if somebody is physically assaulting a woman, then it is punishable under law. But sexual harassment is a broader term. Women may be feeling threatened at workplace without being physically violative. So Supreme Court found that such instances are increasing in an age of globalization. You imagine 1990s. Women started going in large numbers out to places of work. So Supreme Court requested government, you bring a legislation, we have to protect women folk. Despite its repeated directions, no action was taken, no bill was introduced, and finally, exhausting its ordinary remedies, Supreme Court found itself helpless in telling the litigant that, sorry, we are helpless. You want to enforce your right to feel safe at workplace. You are coming to us. But what we can do? Government is inactive. How can Supreme Court express such helplessness to the citizens of the country? So it invoked its special power under Article 142 and issued a set of guidelines mandating it necessary to constitute internal complaints committees at workplaces to address sexual harassment complaints. And Supreme Court declared that these guidelines shall be in operation till Parliament enacts law to prevent sexual harassment at workplace. And these guidelines shall have the force of law till then. And these Vishaka guidelines issued under Article 142 are referred as judge-made legislation. For the first time, Supreme Court made a law by a judgment by invoking its power under Article 142. So there are situations wherein when there is a vacuum in law which is not yet filled but may result in the violation of rights, Supreme Court can issue guidelines under 142. Now a question comes. Is the power of Supreme Court without any limits? Is it a limitless power? In ordinary course, there is no limit in the sense that even parliamentary law does not limit the power of Supreme Court when it comes to giving relief to a litigant. But what about the case where there is law and the law has a sense of purpose and direction? There is no absence of law. Can Supreme Court pass an order which may go against the text and spirit of law? There was a judgment in 2018 on a case from Maharashtra. It was titled, there are two judgments, understand it clearly. First judgment was in 2018. It was titled Dr. Subhash Kashinath Mahajan versus State of Maharashtra. What happened was, you know that there is a law named SC/ST Atrocities Prevention Act, under which people who are protected because of social discrimination, if offenses are made out against them, offenses are committed against them because of their caste, then punishment is stringent. Offenses are non-bailable. But this law was getting misused often. And one such case came to Supreme Court. So where there is law, there is misuse, because human beings use and they invariably misuse at times. So one such case came with respect to a doctor from Maharashtra who would have got arrested. And Supreme Court, taken aback by the misuse of the special law. See, under SC/ST Atrocities Prevention Act, there is no anticipatory bail. Anticipatory bail means pre-arrest bail. If you are apprehending arrest in a criminal case, you can approach the Sessions Court or the High Court seeking anticipatory bail so that you will get released in case you are arrested. So police will have to release you without sending you to jail, so that the person will not landing in jail. This is known as anticipatory bail in simple terms. So when it comes to an offense under SC/ST Atrocities Prevention Act, there is no such thing as anticipatory bail. So if an offense is registered, more often the person may end up in jail. So in Dr. Subhash Kashinath Mahajan versus State of Maharashtra, Supreme Court issued a set of guidelines making it necessary a preliminary inquiry by a DYSP level official so that whether offense is attracted or not gets verified prior to the registration of FIR. It means when such an offense comes, a senior police officer of the district will see as to whether the offense is attracted or not. After such a preliminary inquiry, only offense can be registered. And this resulted in massive protest across the country. And the protest also has a reason. See, if the misuse of law results in creating a separate procedure, special procedure, considering that the affected persons are from the vulnerable segments of the society, isn't there a possibility that the procedure itself may get misused so that the offender may get screened or protected? So it is a stringent law to protect the most marginalized citizens of this country. So they felt apprehensive. There were massive protests and Parliament amended the law to overcome the judgment of Supreme Court. And before that, central government, which was originally not a party to the case, central government filed a review petition before Supreme Court. That is a 2019 judgment named named Union of India versus Dr. Subhash Kashinath Mahajan. So this was the second case. So a review petition was filed before the Supreme Court, and Supreme Court in 2019 recalled its judgment, recalled those contentious provisions in those guidelines, and admitted that when the law was very clear, because law denies anticipatory bail, the law makes certain stringent provisions. So when the law was clear with a sense of direction, Supreme Court should not have issued guidelines which will militate against the law, because then the enacted law would be crossing sword with the guidelines issued by the court. It is one thing to say that there is absence of law, there is a vacuum in law. It is another thing to say that guidelines are there against the law enacted. Supreme Court can invalidate a law, no doubt, if it is against the Constitution. But whether Supreme Court can issue guidelines against the text and spirit of a law, this was something which was taken note of by Supreme Court in the 2019 judgment, and the Supreme Court said we should not have issued guidelines. So in usual course, the power under Article 142 is regarded as somewhat limitless. When there is law with a clear purpose, when there is a clear law, it cannot issue, it is not expected to issue guidelines under 142, which would be violative of the enacted law. So this can be regarded as a limitation when it comes to the power under Article 142. Nevertheless, you will find that in the post-1980 period, Indian Supreme Court embarked on a journey of judicial activism unparalleled in the history of any modern democracy. And in course of its memorable journey, Supreme Court consistently relied on the fountain spring of Article 142 to do complete justice to the marginalized, to the oppressed, to the people who were in jail for decades and decades without ever given bail due to their poor financial conditions. So the journey of judicial activism in India was aided by the might of Article 142. It played a historically prominent role in empowering citizens. But of course, it has its limitation. So Article 142 makes Indian Supreme Court exceptionally powerful. Then Article 141. Oh, you want to write further on Article 142? Think your handouts, it do have material on Article 142. If it is not there, in the next class I'll dictate. I'll ascertain, because we can save 10 minutes. We discussed for around 15 minutes. So on this particular topic, if the material is not there, then I'll dictate in the next class. Let me be reminded. I'll ascertain from my side. Well, Article 141. You can take down. Under Article 141, the law declared by Supreme Court The law declared by Supreme Court shall be binding on all courts in the territory of India. Shall be binding on all courts in the territory of India. Who is Supreme Court to declare law, by the way? Law is to be enacted by legislature, isn't it? So what does it mean? See, law declared means the laws enacted by the legislature may not be so elaborate to cover all aspects of a situation or all social situations which may emerge, and hence the enactments may require interpretation. So India is a common law country. Our legal system is known as common law system. I'll tell you in simple terms what is this. India, America, Australia, Canada, these are all common law systems. On the other hand, many countries of Europe, like France, many of the countries of Africa, which were French colonies, they do have a system called civil law system. And the difference is that, primary difference is that, in civil law systems, statutes are very elaborate. Right to Information Act means the law will have everything whatever is required. And courts are not bound by the previous judgments. The legal principles declared in the previous judgments are not binding on courts. Courts can take a fresh look every time, and laws are there in detail. On the other hand, in common law systems, for example, in India, the law of right to information, it's not just Right to Information Act. Right to Information Act will be there. Before that, Constitution is there, 19(1)(a). Because for the first time, right to information was declared as an inferred fundamental right by Supreme Court, relying on Article 19(1)(a). So when in India you talk about right to information, you have to see the Constitution of India, then Right to Information Act, then the judgments of Supreme Court and various high courts covering various aspects of Right to Information Act passed. So a bundle of judgments also. I'll give you a funny example, a humorous example. If you went to UPSC 10-15 years back, seeking the details of your answer script by way of filing an RTI application, UPSC would have denied you in blanket terms. Sorry, it's not covered under RTI. It would have been the merciless reply, stock and trade reply on the part of UPSC. But now, answer key is released. You can file RTI application. Why UPSC is not in a denial mode? Because there were a few judgments of Supreme Court in between. Till then, UPSC took a stand that, well, candidates wrote answer, but we provided them answer sheet. So it is their answer, but scripted on our answer sheet. So that belongs to us. We are conducting an examination. They don't have any right to know about whatever once they wrote on the sheet. But Supreme Court said, no, it comes under the purview of Right to Information Act. There shall have to be transparency and accountability. So what was not regarded as within the province of Right to Information Act was brought under the scope of Right to Information Act by Supreme Court, by its judgments. So Supreme Court declared principles. So Article 142 is about, 141 is about that power of Supreme Court to declare legal principles while interpreting laws in the light of the Constitution. So in India, what is known as doctrine of precedence is of great significance. All high courts, all courts are bound by the judgments passed by Supreme Court. Judgments means the legal principles declared in the judgment. In casual language, or it is known as ratio of a judgment. Ratio means the essence. Strictly speaking, ratio decidendi. That is the essence of law as visible in a judgment. So the distilled essence of law. So whatever legal principles can be extracted from a judgment of Supreme Court, those principles are binding on all courts of the country. Even though Supreme Court is not bound by its own judgments, but still there is something known as judicial discipline, due to which if a two-judge bench finds disagreement with a judgment of Supreme Court by, for example, a three-judge bench, then this two-judge bench, while expressing their doubt, will place the file before the Chief Justice. Chief Justice would constitute a three-judge bench, and if that three-judge bench respectfully dissents with the opinion of the another three-judge bench, the previous one, then the file would be referred to Chief Justice, and Chief Justice would constitute a five-judge bench. So this is how judicial discipline stands honored. Larger bench will overrule the decision of smaller benches. So in totality, you may say that Supreme Court is not bound by its own judgments, but judicial discipline streamlines that exercise of power. So now you might have understood what does it mean by the law declared by Supreme Court. So the legal principles declared by Supreme Court while interpreting the provisions of law are binding on all courts in the territory of India. So it's about the supremacy of Supreme Court as the source of legal principles. So next you can take down the other provision, article. So here is a question: if there is less than 5 judges in a bench, then which question of law is it? See, when it comes to the cases which reach Supreme Court, 70% of the cases are filed as appeals. So Supreme Court will hear 70% of them are what are known as special leave petitions. Supreme Court will hear a case, most of the civil cases, and in case of some criminal cases also, Supreme Court will listen to a case only if there is a substantial question of law involved. So powers of Supreme Court are broader, but vast majority of cases get dismissed, appeal cases. They will entertain a case only if there is a substantial question of law. Exceptions are there. On factual aspects, they may hear, they have the power to hear, but they evolved yardsticks, due to which, if there is an undecided question of law, then they may hear a case. So, two-judge bench, three-judge bench, two-judge benches do hear and decide on substantial questions of law. But if there is a gross miscarriage of justice happened on factual aspects, then Supreme Court can set aside a High Court decision. Supreme Court can interfere. Well, the next provision, Article 144. All civil and judicial authorities in the territory of India, all civil and judicial authorities in the territory of India shall act in aid of Supreme Court. Shall act in aid of Supreme Court. So it means you will not find such a provision anywhere in the Constitution. You won't find such a statement that all civil authorities shall act in aid of President. No. This is a special provision which declares the primacy of Supreme Court. Understand it clearly without any confusion, without getting misled. The primacy of Supreme Court in the province of adjudication. All civil and judicial authorities shall act in aid of Supreme Court. Mind it, Supreme Court does not have an enforcement wing. For the Supreme Court judgments to be implemented, it is dependent on other judicial authorities and civil authorities. Civil authorities means governmental authorities. So it is the foremost constitutional obligation of all governmental authorities and all judicial authorities to act in aid of Supreme Court. If you read the judgments of Supreme Court, if you go for a first-hand reading, you will find in many judgments there is a term, the long arms of Supreme Court. So these are the long arms of Supreme Court. All civil and all judicial authorities. It is a constitutional mandate that all governmental authorities and all judicial authorities shall assist Supreme Court in administering justice. It's not about supremacy of Supreme Court over other organs of the Constitution. It is about when it comes to adjudicating cases, all authorities shall assist Supreme Court. These are the long arms of Supreme Court. Like for example, in 1990s, in a disqualification case, Supreme Court issued a notice to the Speaker of Manipur Legislative Assembly. So Speaker said, why should I represent myself in Supreme Court? I am part of legislature. So he refused. He refused to accept the notice. Because I am legislature, you are judiciary. We are on equal terms. So then Supreme Court issued a summons to the Speaker. He did not come. Then bailable arrest warrant was issued. Nothing happened. Then finally Supreme Court issued a non-bailable arrest warrant and directed CBI to arrest the Speaker and produce him before the Supreme Court. So Manipur Speaker was arrested and he was produced before Supreme Court. So all governmental authorities, be it CBI, be it Delhi Police, all authorities shall act in aid of Supreme Court. Then comes next point, basic structure doctrine. You can take down basic structure doctrine. Yeah, interestingly, on 24th April 1973, Supreme Court passed a judgment declaring that it has the power to invalidate even a constitutional amendment, an amendment to the Constitution, if it is violative of what Supreme Court called basic structure. So this is known as basic structure judgment, highly debatable, highly controversial, highly influential decision ever passed. So Supreme Court said, Parliament can amend the Constitution, no issue. But it cannot touch the foundations of the Constitution. The very foundational stones of the Constitution cannot be tinkered. because in that case, constitution will collapse. Constitution does not talk about basic structure, but Supreme Court adduced basic structure doctrine. It's a judge-made doctrine, as a result of which Parliament's power was perpetually limited by way of a judgment, which gave enormous powers to Supreme Court. See, when Parliament amends the Constitution, it exercises its power under Article 368. That power is known as constituent power. That is different from ordinary legislative power. When Article 368 is exercised, Parliament becomes the Constituent Assembly. The dead and bygone Constituent Assembly comes alive when the power is exercised under Article 368. So after basic structure doctrine, Parliament's power under Article 368, it is equal to constituent power minus basic structure, in the sense that Parliament's power got perpetually limited. Why perpetually limited? Supreme Court did not elaborate a whole set of features which could be regarded as basic structure. Supreme Court illustrated a few features and said that in due course, in the time to come, if more basic features are to be declared, the court is within its power to declare. It was something like a blank check given by Supreme Court to itself, that in future we have the power. For example, rule of law, parliamentary form of government, separation of powers, secularism. These were all declared as part of basic structure, but not socialism. It was in 1973. Then in 1994, after 21 years, in S.R. Bommai case, Supreme Court declared socialism also as part of basic structure. So what was not part of basic structure became part of basic structure. So it is continuously evolving, as a result of which it potentially limits the power of Parliament. So it is politically regarded as the greatest judicial invasion into the province of Parliament that was meant to happen continuously over a period of time. So basic structure doctrine resulted in a situation wherein judiciary became all powerful. I began with referring to 2014 amendment to the Constitution, NJAC judgment. I'm sorry, this NJAC amendment, 99th amendment. So in 2015, Supreme Court declared it null and void, relying on basic structure doctrine. And also, mind it, never get confused, basic structure doctrine refers to a test evolved by judiciary, by the Supreme Court, to exclusively examine the constitutionality of an amendment act. So it is nothing but a litmus test to exclusively check the legality of a Constitution Amendment Act. Just imagine a government order, it got invalidated. How can it be invalidated? By relying on Constitution. A law enacted by Parliament got invalidated. How? By relying on Constitution. But when it comes to an amendment to the Constitution, it's not the simple text of the Constitution, but the amorphous basic structure doctrine. So this may look a little shapeless because it is evolving. So basic structure doctrine is a test designed by Supreme Court only for the purpose of examining the correctness of a Constitution Amendment Act. That is its exclusive use. Fine, we'll continue. These are the distinctive features. We'll continue with the next topic in the next class.